So this course is Rethinking Intellectual Property, History, Theory, and Economics. In today's lecture, I'm going to focus on history and law, or at least law. Hopefully we'll have time to get to the history. If some of this spills over, if we go over, I'll carry some of this to the next lecture. So I just wanted to kind of give a brief introduction as to who I am for people who don't know who I am and why I'm giving this course. I'm an attorney in Houston. I'm a patent attorney. I've been practicing since 1992. I'm an electrical engineer background, and I've worked for large firms, etc. I've been a libertarian since about 1980 or so. And of course, as the slide shows, it usually begins with Ayn Rand, and I'm going to tie it into the topic of the talk here, which is intellectual property. Like maybe a lot of you, my original perspective was to take what Rand wrote about it and what was in the Constitution, which is that intellectual property is just one type of property law, and was consistent with libertarianism. Although Ayn Rand's arguments sort of concerned me because they didn't make a lot of sense. They didn't seem to come together completely. She seemed to blend her argument into utilitarian and principal concerns, and it concerned me. When I went to law school in 1988, I didn't think much about it, but I kept thinking a little bit about it in the back of my mind and puzzling over this issue because her arguments didn't quite make sense to me. 1992, excuse me, I joined a law firm in Texas, and that's the picture there, the Tom Cruise picture, and I started practicing patent law around 1993, and I started thinking more and more about this issue because I was doing it every day in my practice, and I was searching for the right way to integrate intellectual property theory into libertarianism, and I kept hitting roadblocks, and that is, it didn't make a lot of sense to me. Finally, when I learned a lot more about the basics of Austrian economics and libertarian, anarcho-libertarian theory, legal theory, primarily from the thinkers you see up here, Mises, Rothbard, and Hoppe, finally had a breakthrough, and I just realized the reason I was having trouble justifying intellectual property was that it cannot be justified, and in fact it is not justified. And when I developed a deeper understanding of the praxeological foundations of property law and property rights, it all started making sense. So I started thinking about it, giving a few speeches for Federalist Society meetings, things like that. And around 1995, I started publishing articles about intellectual property and totally opposing it and coming out in favor of complete abolition. Now, this issue was not my favorite issue. It's in a way, it's still not my most interesting issue. I was more interested in property theory and contract and rights and all these arcane issues libertarians debate about. But I wrote an article about this because I just had to sort of get it down on paper, and that became finally my 2000 article, which is now a monograph, and it forced me to rethink a lot of foundations of libertarianism. And one thing led to another. Nowadays, this issue is a lot more a burning issue for libertarians, and so we've come to this point now where more people are interested in this issue. So, go to the next slide here. Let me just go over a basic overview of what the course will consist of. Although there is a chance I will modify this a little bit based upon tonight's pace and see how we do. I'm sometimes accused of speaking too fast in speeches. And tonight's not a speech, it's a course, and so I'm going to take my time and we're going to explore this in depth. I'm not going to give people a working knowledge of IP law so that they can practice it, and that would be too boring anyway. But as of now, we have almost 70 students and from 14 countries at the last count, so we have a nice diverse group here. And tonight's lecture, as I noted, number one there, will be on history and law, and we'll do an overview. And I think it's important, and you'll see as we go through it, it's important to have an understanding of what intellectual property is. And in fact, I think this is one of the big failings of the libertarians who debate on this issue. Let me hit the record button. Thank you. There. I've got it recording now. especially on the pro-IP side, I find that there is an abysmal lack of knowledge of what IP law actually is. Okay? And it seems to me it's incumbent upon you to know what the law is when you're talking about it, especially when you're recommending it. Now, you'll have intellectual property proponents who claim that they're not in favor of the modern version of IP law. And in fact, when you point out various obvious injustices or problems with it, they almost always agree with you, yes, I'm not in favor of that. Okay? But when you ask them what they are in favor of, they're usually not sure. And they are usually against abolishing the current IP law, which to my mind means they're actually in favor of it. Now, those of us who want to understand it and have a critical eye, I think it's incumbent to understand exactly what it is. I hear all the time, I've heard it in the 18 or so years I've practiced IP law, laymen and even other attorneys who are not IP specialists get confused about the difference between patents and copyrights and trademarks and trade secrets and contract law, and they mix it all together all the time. And that's understandable why that is. It's a very specialized discipline, and you cannot expect people to have a detailed knowledge of this very arcane area of the law. So that's what we're going to cover tonight. So I'm going to first cover what the law is and try to go through it in a little bit of detail to give you an idea of exactly what these laws look like that we're talking about. And then depending upon time, we're going to go into some of the historical origins of it and to see how it actually arose in practice. And then you see I've got the others numbered here. We're going to talk about a variety of topics going forward, property and scarcity and ideas, sort of the foundational Austro-libertarian ideas that you need to understand to get a good working knowledge of this. Then we're going to look at the different arguments for IP, the utilitarian case, and the various libertarian rights-based or deontological type cases for intellectual property. And then I'm going to try to integrate it, once we've established what I think is the right way to look at this, integrate it with various libertarian principles and other bodies of knowledge. And then finally, I'd like to conclude by talking about the future, talking about where we can go from here, what activism would entail, what's likely to come, and what a post-IP world would look like. Okay. For this course, I will be assigning readings for each, excuse me, that's my poodles. I'll be assigning readings for each course. The primary two would be my book, Against Intellectual Property, which is fairly comprehensive, although it's compressed, and it's very theoretical. And then the very good book by Boldrin and Levine, Against Intellectual Monopoly, which are both available online, and I have them both linked on the resources page of my website, C4SIF, Center for the Study of Innovative Freedom. Okay, and on the resources page of the course, I have various suggested or required readings, actually, and some optional readings too, which I have some of them listed here, but they're all on the resources page. That's what I'll be relying on mostly today. Now, the basic inquiry is intellectual property a legitimate type of property? This is what the debate is about. So we already know there are different types of property that the law recognizes and that we libertarians respect and agree that are types of property. And the two basic types of property are real property, the typical example being land, and personal property, like cars and apples and gold. Now, this is the common law terminology. In the civil law countries, France, in the continent, in Louisiana, my home state, these would be called immovable and movable. Real property is immovable, and personality is movable property. So then the question is intellectual property a legitimate third type of property or not? And that's what our inquiry would be in this course. So the question is, what is intellectual property? Is the concept even coherent? Now, you have a lot of debate about this topic. A lot of the opponents, my fellow opponents of intellectual property, refuse to use the term. They're more of the mind that, if you name something, you give it power. Well, I prefer to stick with the positive law and the fact that people use this term and just ask, what is it, and is it justified or not? So, It is an umbrella term in the law, and it covers several different types of rights, which are related in some sense, but there are many differences between them. So you can think of intellectual property, or IP, as a broad concept that covers different types of rights that have to do with intellectual creativity related to ideas. That's why the word intellectual property. Although we'll see as we get down into the lecture, the reason this term came about was for more propaganda purposes rather than descriptive. So intellectual property rights are rights to things that are intangibles. Intangible things. That's ideas as expressed, which are copyrights, or as embodied in a practical implementation, which is patents. And we'll discuss the details of that in a minute, so don't get hung up on that too much right now. Now, one of the writers, Tom Palmer, refers to the rights of IP in so-called ideal objects. In other words, it's a right in some kind of idea that's floating out there in space. It's not an actual piece of tangible property. It's instantiated in some kind of material property, okay, like a book. So the IP of a book is not the physical book that you hold. It's the ideas that are in the book, or the patterns that are represented on the page. Now, as a practical matter, these rights are always resolved in terms of tangible things. That is, let's say you accuse someone of copying your book. Well, if you sue them and if you win, what do you get? You don't get the intangible book idea back. You actually get money from the guy, or you get a court order telling him not to do something with his body or with his paper. So in a way, these things always resolve down to tangible things. But they can be thought of as rights in ideal objects. Sorry about the choppy video. So let's talk about the types of intellectual property. So there are 4 traditional types. And the 2 big ones I have bolded there, patent and copyright, are the 2 big guys here. Now, under copyright, there are sort of related things. One's called moral rights, which is more of a European notion. And there's something called common law copyright, which has largely disappeared as well, which is not really that related to modern copyright. And then the other 2 big ones are trade secret and trademark. So these are the 4 types of IP that are traditional. Now, there's another type of right that is long-standing reputation rights, which are represented by defamation law. The 2 types of defamation law are libel and slander. You might have heard these terms, and people use these interchangeably as well. Well, just to let you know, libel is the written form of defamation. Slander is the oral form of defamation. And you can remember that because libel has an I in it, and so does written. So they're both just the types of defamation. Now, in my view, this is also a type of intellectual property right. It's based upon the same types of arguments, and it's illegitimate for similar reasons, although it's not traditionally classified as a type of IP right. So I would add to the first 4 reputation rights. In the last several decades, other new rights have been invented by the legislatures around the world. Database rights, which are not in force in America yet. There have been attempts, but I believe they are in force in some countries. These are collections of information. They used to be protected in America under copyright law, but a Supreme Court case called Feist, F-E-I-S-T, maybe 20 years ago, basically ended what's called the sweat of the brow doctrine. Under the sweat of the brow doctrine, copyright traditionally is only obtained for what's called original creative expressions. And the idea was that if you just collect information, like let's say a phone book or a map, these are just completely factual descriptions, and there's almost no creativity in the way you arrange, say, the names in a phone book. It's just alphabetical. And even maps have very little creativity. There's some artistic background, but someone who wanted to copy a map would just take that out and just take the bare information. And the courts, there was an old doctrine called sweat of the brow. Okay, I'm going to reload the video. Hold on a second. So, there. I've got it recording now. this will be better for some people. I just reloaded my video. So I was explaining under the old doctrine in the U.S. law anyway, there was something called sweat of the brow, and the idea is that if you put a lot of effort into collecting some facts that are useful to people, that would sort of be a substitute or a proxy for what's called originality, which is a requirement of copyright law. Well, the court in Feist, the U.S. Supreme Court in Feist, said that doesn't count. So basically, they struck down copyrights and maps and things like that. So there's been a movement since then to try to get database rights protected legislatively, which have failed so far. But I do believe some countries have this type of right. There is a type of right called a semiconductor mask work. This is sort of the way that a semiconductor layout is done for these chips, like Intel makes, things like this. There's also some very bizarre special legislation that protects the way boat hulls are designed. And there's now a movement for to try to impose intellectual property in areas that have traditionally not been protected, like fashion. So there's a movement actually to do that now. It probably will fail, but it's always being expanded. So I'm going to focus in this course on copyright and patent, and I'll explain why as we get down into it. But let's talk a little bit about copyright in detail right now. A copyright is a right that's given to authors. These are all key terms in the law of what's called an original work. And the examples would be books or articles and movies. And now computer programs. This didn't used to be the case because computer programs are functional, which is usually what's covered by patent law. But now there's said to be expression in the code of a computer program. So that's copyrightable. Now, what is copyright? Most people actually think it's just the right to copy, make a literal copy of something, especially because nowadays in the MP3 world or in the digital world, that's what we do, right? If you want to copy a file, you make an exact digital duplicate of it. But copyright is not restricted to that merely literal type of right. Copyright covers the right to reproduce, but the reproduction doesn't have to be just literal. It can also be a functional reproduction. So you can make some changes and it would still be a reproduction. It also includes two other very important rights, without which copyright would have a lot fewer of its negative sort of consequences. One is to prepare derivative works, and the other is to perform or present the work publicly. Okay, so this bundle of rights is copy a DVD of the Star Wars movie. Now that would be a reproduction. But if I were to write a novel or film a movie that said, Grayson Lilburn's Further Adventures of Han Solo, well, that's a derivative work. It's based upon the original idea, and that is also prohibited, or that is the exclusive right of the copyright holder. Okay? Now, the copyright protects only the form or the expression of ideas, not the underlying ideas themselves. That would be the functionality. So in a computer program, copyright covers the way it looks, actually, the way it's written. But someone else could reverse engineer that program and write their own program using the same flowchart, let's say, and that would not violate copyright. That might violate patent, but it would not violate copyright. So if you think about it, what a copyright is, it's a right that the state grants you to, Ethan, close that door, please. It's the right the state grants you, okay, to ask a state court to penalize someone who's infringing your copyright. So it's like a license to sue someone. So like I said before, it protects original works of authorship that are fixed in a tangible form of expression. It has to be fixed. If I sing a song, an original song, on a stage, and the words go over the air and people hear them, there's no copyright in that. It's never been fixed in a tangible form of expression. It has to be written down or recorded, something like that. Okay? Now, the term of copyright right now, in the U.S. at least, and in most WIPO-compatible countries, is the life of the author plus 70 years. 70 years. Okay? So if you write something when you're 30, you live to be 90, then you're talking 140 years of term. Or 95 years if it's a work for hire. Now, what's a work for hire? A work for hire is the following. If someone pays you to come up with some copyrightable work, and you have a written contract, and the contract in writing says that it's a work for hire, in that case, the employer or the person who hires you is the actual author under copyright law. And they own the copyright because they're the author. The original author is actually not legally the author under the copyright definition. So that's what a work for hire is. But basically, you can think of copyright as being about 100 years. I mean, it's very long, 100 years or more. Now, what's important about copyright, and this is another mistake that's commonly made when people talk about copyright. For example, if they see one of my books, which has a copyright notice in it, they'll say, well, you copyrighted your book, which is hypocritical. Now, I don't think it's hypocritical, but even if it were hypocritical, the point is I didn't copyright it. Copyright is automatic, unlike patent. You don't have to apply for it. In fact, you cannot even get rid of copyright. It's very difficult to get rid of copyright. If you have a contract with someone and they pay you consideration and you have a signed agreement, you could assign your copyright to them. Otherwise, it is almost impossible to get rid of copyright. So they're, as I've written before, they're very sticky. You don't have to have a copyright notice to have copyright. You don't have to register a copyright to have copyright. These things are optional. They give you some procedural rights, but they are completely unnecessary. So this is a common misconception. So it's really hard for the IP advocates to blame IP opponents for having copyright because the system that they're in favor of grants us these copyrights, whether we want them or not. And as an example, I have a copyright in this page. This is an original work of expression. It's fairly short, but it's fixed in a tangible medium, and I just have a copyright in it. The federal government gives me this right, whether I want it or not. So what you can do is you can think of copyright as a noun, not a verb. Now, registration was not always optional, which is why copyright used to be more appropriately used as a verb in some cases. I see a question here. I'll take a quick break. You do have to register a copyright before you sue. It's sort of like a formality right before you file the lawsuit, but you don't have to do it until you want to sue someone. And you can do it the day before you file the lawsuit, literally, along with the papers. And it takes a $25 fee or something like that to file it with the Copyright Office. So no, it doesn't have to be registered to have a copyright. We won't go into this in detail. This is just an example to show you of, if this is a flowchart you would go through if you wanted to figure out when a copyright in a fixed work expires. Okay, so you can see it's very complicated. The law is just a very complicated, exception-ridden legislative scheme that Congress has written. I don't know. Okay, so let's go to the next slide here. Now let's talk about patents here. You see on the upper right corner, that is a picture of what's called a red ribbon copy of a patent. They're called red ribbon copies because when you get it in the mail, it's a paper copy with a thick cardboard cover and with a little red ribbon on the cover. It looks very fancy, and it's a right that you achieve at the end of a registration process. So unlike copyright, you have to apply for a patent. Okay. Now, what patents are for is for functional, practical inventions. You can think of it as being for gizmos, mouse traps, things like that, or methods, ways of doing things. It has to be useful, and it grants the inventor a limited monopoly on the manufacture, use, or sale of the invention. Now, the monopoly actually doesn't give you the right to perform or use the invention. It only gives you the right to stop other people from doing it. This is another important point that is key to the way patents work, which is also largely misunderstood by non-specialists and non-patent attorneys. Now, there are three categories of subject matter that are not patentable. These are things that are considered to be too general or too broad to be patentable. These are laws of nature, like E equals MC squared, or natural phenomena, and abstract ideas, which that's a varying concept in the courts. Right now it sort of means mathematical algorithms that are not connected to any tangible result in reality, just sort of like a formula on a page. or even business methods nowadays. Business methods used to be unpatentable, then they became patentable about 10, 15 years ago, and recently the courts have choked back on business method patents on the abstract idea. But the basic idea is that patents allow you to apply for a patent on an invention, a useful, practical invention. The law was changed in 1995 pursuant to the GATT Treaty, and patents used to last for 17 years from the date of issue. So you file it on day one. It might take 3 or 4 years for the patent to issue, maybe 1 year, maybe 2 years. And then whenever it issued, you would have an issue being granted by the state and being enforceable, where you could assert it against people. You would have 17 years. Well, that was what a submarine patent was under the old law before 1995, or before 98 rather. When you file a patent application, it's secret. It's not made public until it issues. And there was really no limit under the old law in how many times you could sort of retread this patent application, change the claims a little bit, and keep it going. So there were some patents that were 20, 30, even 40 years being prosecuted over and over again by the inventor. And they were kept underwater, so to speak. In the meantime, someone would invent the same idea independently, and they would start using it. And it would become embedded in the industry, and no one would even have a patent on it. It would just be a technique being used, like windshield wipers in cars, intermittent windshield wipers, or something like that. Finally, the guy would let the patent get allowed. He would tailor his claims to cover the current technology, and the patent would emerge like a submarine. Well, so under the current law, that practice is reduced a little bit for 2 reasons. Number one, under current law, patents are now published after 18 months after you file them, even if they take 10 years to issue. And number two, the term is 20 years from the date of filing. So if you take 5 years to prosecute, it's called prosecute the patent with the patent office, then you only have 15 left. So the longer you take, the less term you have left over at the end. So I usually say patents last about 17 years still, because the typical prosecution time is about 3 years. So you still have about 17 years left. So like a copyright, a patent allows you to petition a state agency for the monopoly privilege, which you can use in the courts of the state. And I don't mean the United States, I mean the central state, the federal government, to sue someone. So it's a state-granted right that allows you to petition the courts to penalize someone who's infringing your patent grant. So in this sense, copyright and patent are very similar. I see a question here about DNA sequences in genes. This has been a hairy area in the law. There's the famous Harvard mouse case in which the court did say that artificial life forms could be patented, but human life could not. And human genome sequences are sort of in between, and the law is unsettled in this area. Although I believe just a couple of days ago I read that the U.S. Government took the position that they believe gene patents should not be permitted. So we'll see how that pans out. Gene patents may be restricted as well going forward. There have also been restrictions in the past. It's 7 o'clock. There have been restrictions in the past on medical device patents, or medical procedure patents, surgical techniques, on the grounds that it's unethical for a physician to get a monopoly on a procedure that could, save someone's life or be necessary for surgery, something like that. Not on the devices, but on the medical procedure itself. So everyone, Congress will come in and try to choke back on the excesses of this law that they came up with in the first place. Now, let's talk about patents. There's not just one type of patent. There's 3. There's utility, plant, and design patents. Now, what we'll talk about in this course and what you hear about most of the time when you hear about patents are utility patents. These are things that have utility or usefulness. This is typical inventions. Plants are for asexually reproduced plants. They have a shorter term, and it's a very narrow area, and it's not really that hot of an area. Design patents are a funny sort of hybrid IP right that's in a way in between patent and copyright. It covers the ornamental aspects of some feature. And I'll give you a few examples in a minute of that. These are not that important either. But by the way, if you ever see a patent, and the patent number is usually a 7-digit number, like 7, comma whatever, patent number 7 million, whatever. Design patents start with the letter D, big capital D. So you can tell it's a design patent from that. So like I mentioned before, the way you get one is you file a patent application with the United States Patent Office. And this guy named an examiner, who's usually an engineer, not a lawyer, but an engineer, examines it and tries to make a decision about whether it should be granted as a patent. That is, whether it's new enough or non-obvious enough, has utility, and is well written enough. It satisfies all the requirements. So he goes back and forth with a patent lawyer, usually, in a process called prosecution. I know it's a funny word, but that's just what patent attorneys use. So the patent issues, and you get the red ribbon copy I showed you earlier. And like I said, it gives you the right to exclude others from making or using or selling or importing this invention. So let me give an example about what I mentioned earlier about how it's not the right to use your device. Okay, it's the right to exclude others. So in a way, it's only a destructive right. You can only force someone to not do something. So let's say that up until now, there's only 4-legged chairs. These are commonly in use. One guy thinks of a 3-legged stool, and he files a patent on that. So he files a patent on a seating object or a seating apparatus having a seat portion operatively connected to 3 legs, having a triangular cross-section at the bottom, something like that. So he obtains a patent on 3-legged stools. Now that means he can stop anyone else from making a 3-legged stool. Okay, now let's say a second guy, let's call him B, thinks to himself, if I put a back on that stool, it'll be a lot more useful. So he files a patent on a 3-legged chair with a back. And his elements are, and a seating apparatus having a seat, 3 legs, and a back connected to it. Now, let's suppose that he gets a patent on this. That means he can prevent the first guy, let's call him A, from adding a back to his stool. But he can't make his own stool, even with a back, because it would still have a seat and 3 legs. And A can stop him from doing that. So in this case, neither one of them could actually make a 3-legged chair. Now, we'll discuss later on, what's commonly done there is they may cross-license to each other. They may give each other permission to use each other's patents. And maybe one pays the other, something like that. Or maybe one buys the other one out. Okay. Now, this is all in the area of abstract ideas. If you haven't, we're talking about patents, but people don't know what they really are. When I started practicing patent law, before I'd seen one, I didn't really know what they were. So I'm going to tell you what the parts of the patent are, but I'll just show you one actually. So it has various parts that are required by the law. It has an initial section that has sort of a summary called an abstract, a title, the inventors, and then whoever the owner is, usually the employer of the inventors. Has a detailed description of how to make and use the thing you claim a property right in, and has drawings to illustrate it usually. And then it terminates in a set 1 or more claims. Now the claims is where the heart of the patent is, what you get a property right in. The detailed description is actually the original bargain. Most IP proponents actually mistakenly believe that the stated purpose of the patent law is to encourage innovation. Actually, it's to encourage disclosure. The idea is that if you didn't have a patent system, you would have innovation, but the inventors would keep their ideas secret because they would be afraid of being copied. So they would use trade secrets, and they would keep their ideas secret. So the idea here is that the government makes a bargain with you. They say, listen, if you will give us a full disclosure of exactly how you make this thing, then we'll give you a monopoly, a temporary monopoly in that idea. But in the meantime, everyone can read your description, and they can understand what you're doing. That way they can start experimenting or learn from your ideas, and then when your patent expires, then they're free to actually use it. So that's the idea. And sort of a byproduct of that is the idea that this monopoly right also lets you charge a higher fee and that might give you an additional incentive to innovate in the first place. That's sort of the idea behind patents. I'm not going to read this whole claim, so don't freak out about it. It's very technical. This is actually a claim from one of the patents I prosecuted for my current employer. The patent number's here. You can see 6560259, and it starts with an independent claim. Every patent, every claim is a sentence, starting with a number, and then the letter A or the word A or the, and ending with a period. So you just state the elements, and I bolded the elements here. So this patent is for a certain type of laser, comprising, which means having at least the following. And I've got them A, B, and C here: a cavity, a diffraction grating, and a semiconductor layer with certain characteristics. That means any competitor who makes a laser that has these elements, even if it has other elements, is infringing this claim. And then sometimes there are dependent claims. That's one that refers to the other claim. Here's claims 2 and 3. You can see it says the laser of claim 1 wherein, and then it adds a limitation. Or 3, the laser of claim 1 further comprising another feature. Now, there's a strategical reason patent lawyers do this, but we don't really need to go into that here. Basically, you want a spectrum of claims in there. The reason is that the higher claims are usually broader. That means they cover more things. So there's more people that might infringe these claims. On the other hand, there's more prior art out there that it covers, and so it's easier for a competitor to find a piece of prior art, which is like a previous publication or something, that the examiner hadn't found, and shoot it down in court, get it invalidated. In that case, you would go to one of the narrower claims and hope that it would still cover the competitor's device, but it would survive the invalidity challenge. I see a question: can a patent be renewed for an additional term prior to its expiration? The way it works in most systems and in the U.S. system is, say the patent issues on day 1. Then there are periodic, every 3.5 years, there's a renewal period. You have to pay a fee to keep it alive, and these fees go up exponentially. So at 3.5 years, you have a 12-month window around that time period to pay the 3.5-year renewal fee. And I believe it's about $950, or half of that for a small inventor. And then it goes up maybe by a factor of 2 or 3 for the next one at 7 years, and so on to the end. And the purpose is so that patents that are not being used maybe expire a little earlier than normal because the renewal fee is not paid. Okay, I'm going to show you the patent that we just talked about. I'll show you here. The detail doesn't show through very well on this slide. In fact, it's not showing it all here. Give me a second. Okay, this is the patent we were just talking about. This is the front page, and it has the different fields I was telling you about. It's got the name of the inventor, the title, etc. It's got one of illustrative drawing, etc. So this is what they look like on the inside. You'll see my name is there over the word abstract as the attorney who prepared it, and then the name of the examiner is about him, etc. And there's a lot of detail in here, but this is just the details, the guts of patent law, what it's like. I've got some other figures. Let me go and skip down here to slide 26. Here's some of the drawings, but let me skip to slide 26. You can't see the details on this. This is just a funny poster that patent lawyers hang on their walls. It's called Patents Progress. It's sort of modeled after that, that Milton thing. And it just shows the stages you have to go through to get a patent. And at the top there, you can see it's almost like the patent issues and you're reaching heaven. So this is how they conceive of patents. This is a flowchart that shows you some of the steps of patent prosecution. And the steps are not important here. I just want you to see how sort of detailed and complicated and, in a way, arcane it is. This is how you would determine, this is a flowchart that you would use to determine whether a certain process or invention is patentable or whether it's too abstract to be patentable. And this has to do with computer-implemented inventions. I just have a few examples of patents here. Most of them are actually silly ones and ones that are ridiculous. I don't mean to imply that every patent is for a bad idea. A lot of patents are for good ideas. This is, I believe, a design patent. It's just a bumper, a trailer hitch shaped like a Bible or stamped with a Bible. Someone got a patent on that. This is a utility patent, a toe puppet. You just put it on your toe and you can use it to entertain someone. This is a peanut butter and jelly sandwich that has no crust, but it's sealed. So someone actually obtained a patent on this, a food patent. This may be a design patent. I don't have the number, but these are just garbage bags shaped like colored, designed to look like pumpkins. So I guess they have a decorative purpose. It's probably a utility patent. This one is a silly patent, a kind of famous patent. It's basically someone obtained a patent on a method, a way of swinging sideways on a swing, which probably most of us have done sometime in our childhood, instead of swinging forward, which is obviously ridiculous. This is a watering stand for a Christmas tree shaped like Santa Claus, so it has a dual purpose. This is an older patent. It's a way of initiating a pledge into a fraternity. So he gets a shock on his feet from some kind of electrode device there. This is a method of exercising a cat by playing a laser pointer on the ground in front of the cat. So all these things all these have at least one claim. This is a pat on the back apparatus. I'm just going to go through these. They're not that important, really. This is the one-click patent you might have heard of. You see Jeff, in the name of the inventors here in the left column, Jeff Bezos, who's the CEO of Amazon, he's listed there as one of the inventors. This was the one-click patent that Amazon used to strike against Barnes & Noble right before Christmas about 5 years ago and caused him a lot of trouble. And Jeff Bezos has gotten a lot kind of anti-patent in the meantime. There's some kind of pooper catcher, some kind of jeans that have a hole in them revealing buttock cleavage. None of these is a design patent. This is an older patent. Back in the day, there was a concern about being buried alive before embalming was popular. So some people would wake up in their coffins, and so the idea was to have some little string in there you could pull that would set off a buzzer or something, an alarm, if you woke up inside a coffin. So someone got a patent on that invention. This is a way of combing your hair to hide your bald spot, which I don't have enough hair on the side to use this one. A method of putting. So if someone got a patent on this, then theoretically they could actually get a cease and desist order from the court and say, telling Tiger Woods, you cannot manipulate your body in this way. So in a way, it's a way of controlling someone's body. A way of measuring, figuring out a bra size with direct measuring the breasts. Now, let's go through a few myths about patents and IP in general. One of the myths is that patents are for the small guy, the small inventor to get his patent and have a lot of success with it. Well, the truth is that most patents by small inventors and by companies are never used. They're basically just wallpaper. I've known a lot of independent inventors, small guys, they pay $10,000, $15,000, $20,000 on lawyers to get a patent, and they spend all their energy and effort on that, and the patent never does them any good. It just goes on the wall, and then they can show it off to people. They have a red ribbon copy, but it's not used. And mostly patents are used for corporate wars and for protectionism, which we'll get into. Another myth is that the first guy to invent something, and the other myth is first to file. People are confused about this issue. The idea is that the first guy to invent something is entitled to a patent on it. Actually, the U.S. system has something like that. The first person to invent, if there are two people that invent the same thing around the same time, the one who invents it first would win in a battle called an interference, not the first one who files. Most other countries have the first to file. They say whoever files their patent application with the patent office first would win. Interestingly, Ayn Rand, in her article on patents and copyrights, she actually thought that the U.S. had the typical system, which is first to file, and so she sort of bent over backwards to explain why that would be justified. So she basically was wrong, thought America had a first to file system, and explained why that, of course, had to be right. She was so sort of biased towards the American way of doing things. Of course, she was wrong. It's the first to invent here. You often hear laymen talk about a poor man's patent or sometimes a poor man's copyright. I have never in my career ever seen that done. I've heard people talk about it, and we always tell them, do it the right way. But the idea was you would write your invention down on a piece of paper or some copyrighted work, seal it in an envelope, and mail it to yourself through the U.S. Post Office so that you could prove in court later that you had this idea on this time by showing the postmark on this envelope that you had never opened. But of course, that wouldn't really be good proof in court. It's too prone to tampering. There's another myth you'll hear quite often that patents are the sort of conspiracy theories. The idea that patents are bought, like there's all these 100-mile-per-gallon inventions out there, and all the big oil companies buy them up to keep us from having more fuel-efficient cars. But the problem with that is, as you can see from what I explained, the entire rationale of the patent system is that the bargain is, we'll give you a monopoly on this if you disclose it, and then these patents are published. I mean, they're inherently published. So anyone who thinks that there are 100-mile-per-gallon carburetors or fuel injectors or engine designs out there that are patented and then bought up by big oil, you're welcome to go to uspto.gov and do a free patent search and find it. And if it's not there, then there's nothing that's going to prevent someone from doing it or patenting it on their own. So that makes no sense whatsoever. I mentioned earlier already, this earlier one, the right to practice. Most people get really confused on what a patent gives you. They think it gives you this monopoly right to practice your idea. It doesn't. It only gives you the right to stop other people from doing it. I gave you the stool example already. Yeah, one of the commenters made a comment about the small companies, and you're right about that. That's why I mentioned earlier that these patents primarily benefit large companies, because what will happen is they will each will acquire a very large patent arsenal. It costs millions of dollars to acquire these things, and one of them may eventually sue the other, partly because if they approach each other to do a deal, they might get in trouble with antitrust concerns. So instead, one of them sues the other, and then they finally settle, and they grant each other a license to each other's patents. And so all these big guys have the right to sort of freedom of action within the space. The little guys have very few patents, and they don't have enough heft to sort of get into the game. They don't have enough chips. So it works as sort of a barrier to entry, as a protection, this type of thing. There's also sort of a myth about the lone genius or the towering genius, the idea that there are these great men in history that come up with this amazing idea and they should be rewarded. And of course there are some, but even these guys stand on the shoulders of other people. Even they've inherited a huge body of knowledge, of human knowledge. And quite often, an invention is invented because its time has come. And this is why there's the interference proceeding I mentioned earlier. This is why there are rules on who wins in the case of a near-simultaneous invention, because in most cases, an invention would eventually be invented, and quite often would be invented soon after the first guy did it by the other people working on the same problems. And finally, let me mention one other myth. No, it's not a beer, it's a Perrier, sorry. There is a mistaken idea that, let me go back to copyright for a second. Copyright has to do with copying or reproducing others' ideas. And so quite often, if you use someone else's idea, you're charged with theft. Now, there are problems with that idea, which we'll get into. Namely, the originator still has his idea. It hasn't been taken from him. But you are copying it, and that is an essential element of charging someone with copyright. They have to have copied or gotten the idea from you. If they came up with it on their own, they're okay. It's just very unlikely. But the idea, a lot of the defenders of patents sort of have the same idea. They say, well, don't steal my ideas. Well, the truth is, for patents, think of the examples I gave earlier, like about the stool or about my patent that I showed earlier. To be liable for infringement, you only have to be making or using or selling something that is described in that patent. That's it. Doesn't matter where you got the idea from, even if you came up with the idea on your own. So patents do not require copying, and in fact, it's not usually alleged in the case because you don't have to show it. And in fact, it's usually not present. I've seen statistics that show that in the vast majority of patent lawsuits, the accused infringer, even if they're guilty, they came up with the idea on their own. It's just that it happened to step on the toes of an existing patent, which was buried in the millions of patents of the patent office. And in fact, most people don't realize this. Independent invention is not a defense, which I just mentioned. Even prior invention is not a defense. Now, that might seem contrary to what I said earlier, that the first inventor wins in America. But that's only in certain defined cases where they both file a patent application, and they're both trying to get a patent. And then you have an interference battle to see which one wins. But in a case where, let's say, A invents a process for mixing chemicals, and he does this in his chemical plant, and he keeps that process secret. Let's say it's a nozzle. Now, all he sells is the improved chemical, which is not patentable. It's just some product. 20 years later, company B independently invents this same process, and they file a patent on it. Now, when they get that patent, they can actually get an injunction and shut down the original guy, because he's not a first inventor in the definition of patent law because it wasn't public. That's just another arcane result of patent law. Another myth is, defenders of IP will say that it existed at common law. It's sort of an evolution of common law. This is definitely not true. It's a big statutory scheme. It's a modern invention. It's only a couple hundred years old, these types of patent systems, 200 or 300 years old. There was a famous debate in Parliament in England. There was a guy named Lord Camden. He was, arguing against the London booksellers. And in response to claims that copyright arose in common law, now I won't have a lot of quotes in this lecture, but let me have a couple here. He said that those claims are founded on patents, privileges, Star Chamber decrees, and the bylaws of the Stationers Company, which we'll get to. That's a monopolistic sort of a censoring company. All of them, the effects of the grossest tyranny and usurpation, the very last places in which I would have dreamt of finding the least trace of the common law. Now, there was something called common law copyright, but it had almost nothing to do with modern copyright. It was just a narrow right of an author to prevent someone else from publishing his unpublished manuscript, like if he stole it from his desk drawer or something like that. In a way, it was almost like trade secret. And there's other myths. I'm going to skip some of these now to move it along a little bit, and we'll get to these later anyway. Now, what about the other types of IP? I'll go over these fairly briefly because we're going to focus in this course on patent and copyright. But trademark is basically a mark you use that identifies where a good comes from. So when you see this product in public, you know who made it, who you're buying it from. And it just prevents you from using a confusingly similar mark, too confusing as someone else's. That's confusing to the customer. Okay? They can last forever. You can keep renewing them every 10 years. A trade secret is basically just a secret, something you keep secret that gives you a competitive advantage. Okay? And they're protected under state law. Now, like I said earlier, one disadvantage of relying on trade secrets is someone else could independently invent this later and get a patent on it, and then you're in trouble. So the existence of patents leads people not to rely on trade secrets as much, which was one of the goals of patent law, was to force people to disclose information. Okay? So, focus on this course will be patent and copyright. I may touch on reputation rights, depending upon time, because in a way I think reputation rights are the third worst form of IP. But basically every form of modern IP has some unlibertarian aspects. Trademark law has problems. Number one, the wrong plaintiff. It shouldn't be the competitor. It should be the customer who's defrauded. Fraud should have to be shown. It doesn't always have to be shown. And there's modern extensions of trademark law called anti-dilution, which are unlibertarian. And there are problems with trade secret law as well, and all the other newer IP rights that we talked about have problems. But the reason we'll focus on copyright and patent is they're the most abusive, they do the most damage, and once you understand the case for them, then you can easily figure out the other case for the other types of IP. Now, I will say that I go back and forth on which ones I think is worse, which one I think is worse, copyright or patent. Copyright lasts a lot longer. But patent is also very harmful in their term, especially in this fast-moving technology world. Now, let's talk about history a little bit. And I think we'll take a break in about 10 minutes, maybe a 5-minute break, and then we'll have a Q&A session. I don't know if many of you have read Rothbard's criticism. Is there a country that doesn't have a patent system? I'm actually not sure. I'm not sure about that. I know there are different types of patent systems in different countries, but yeah, I don't know. There's a famous article by Rothbard, one of my favorite, Robert Nozick and the Immaculate Conception of the State. And basically, he criticizes Nozick's Anarchy, State, and Utopia, which is not an argument in favor of anarchy at all. It's an argument for the minimal state. And, Nozick has this immaculate conception that the state can that an existing state can arise through legitimate processes. And he has this kind of rosy picture of how it could arise by an invisible hand process that doesn't violate anyone's rights. But Rothbard said, this is ridiculous. If you look at the actual history of states, and I'll read the bottom quote here, for every state where the facts are available, originated by a process of violence, conquest, and exploitation, in short, in a manner where Nozick would have to admit violated rights. So in other words, this sort of rosy myth of the way the state originates is nonsense. Well, we have something similar for patents, or for copyright and patent. What I'm going to call it here the Immaculate Conception of IP. And this goes like the story you've heard maybe on Saturday morning specials, or these PR ads, or patent office promotionals, or all these placards you see at science fairs, or things like this. The idea is that America had these wise founding fathers, and they realized that there's a natural right to benefit from your creations, and so they wisely put it in the Constitution. Article 1, Section 8, Clause 8 put in the copyright and patent clause. And let me take a brief detour here and explain something here. If you read it, it said Congress has the power to promote the progress of science and the useful arts. Now, in our modern eyes, you would look at that and you would say, well, science has to do with patents and arts has to do with copyright. It's actually the opposite. Science meant, just knowledge, and had to do with artistic works under the terminology of the late 1700s. And arts meant artisans, craftsmen, people that came up with useful objects and devices. So that has to do with patents. You'll notice that clause does not talk about trademark and trade secret, which is why the federal trademark law, which is called the Lanham Act, it only covers interstate commerce. That is, goods that travel in interstate commerce. So they base the power to do that on another clause of the Constitution called the IC clause, or the Interstate Commerce Clause. And there's still state trademark laws. Trade secret is mostly state law, although there are some federal aspects too. Of course, this conventional account is very confusing because they pretend like it's natural law or rights-based, and yet they mix in all these ideas about we have to find the right balance. And the terms of these IP rights, especially patent and copyright, are finite, right? They end after 17 or 100 years. Why would a natural right last after a shortened time? And then there's always debate about how long the term should be, although it always seems to get longer and longer. Okay, so that's sort of the rosy picture of patents, that the government gives us property in our ideas to encourage it and to respect our creations. Now, what's the real story? The real origins is that patent and copyright originated in monopoly privilege, and censorship. So for patent, this arose from the practice of sovereigns issuing monopoly privileges to favored people to raise fees or to ingratiate them. Comes from the word patente, a Latin term, which means open letters, which were just letters the monarch granted authorizing someone the exclusive right to do something, like the only person who could sell a type of good in a given area. It was mercantilism and monopolies. In fact, the first patent statute, modern patent statute, was the Statute of Monopolies in England of 1623, had 14-year terms. But one thing that's not commonly known is that actually, in a way, improved matters because it took away the power from the king and gave it to Parliament, and it reduced the power. It made it less arbitrary. And what it did basically is it replaced what was sort of an indefinite and broad and arbitrary grant of monopolies by the king with a more definite and more restricted monopoly grants. Still bad, but an improvement in some ways. So it wasn't really to advance the IP. It was to keep the king from doing too much of it. Now, at the time of the statute of monopolies, patents weren't yet called intellectual property. They were called monopolies. So this term has been used as propaganda since to help sell this idea. And here's a good quote by Fritz Machlup, one of the an economist who did a detailed study of patents in the mid 20th century. Those who started using the word property in connection with inventions had a very definite purpose in mind. They wanted to substitute a word that had a respectable connotation, property, for a word that had an unpleasant ring or privilege. And this is what has been done. And this is why it's a little bit ridiculous when you see IP proponents now, they almost argue by definition. Well, as a type of property, aren't you in favor of property? Well, I see that this propaganda technique continues to work. One interesting thing is that you'll notice that IP advocates accuse IP infringers of being pirates, right? When they're not real pirates. They don't actually break things or stomp onto someone's boat and kill and murder and rape and steal things and leave them worse off. And ironically, letters patent were used in the 1500s literally to authorize pirates or privateers, they were called. Francis Drake being a notorious example. He was given a letter patent authorizing him to engage in piracy, and he used it, and to much acclaim. He came back home with lots of treasure from looted Spanish ships and things like this. So piracy, if anything, goes hand in hand with patents. It's not what people who oppose patents and copyrights do. IP is clearly a monopoly. It was called this originally. Some libertarians who are in favor of IP get indignant if you call it a monopoly. They think it's an unfair technique. But that's because our statists nowadays are much less honest, right? They don't like to call things like they are. We used to call the Department of Defense we have now the Department of War because that's what it did. Well, now we're more touchy-feely. We come up with euphemisms. But it's widely recognized that patents are state-granted monopolies. Even some libertarian advocates of them do, like Richard F. Stein. The courts do. Arnold Plant, Rothbard has a good analysis of this. They're clearly monopolies. I mean, the first patent statute was the statute of monopolies. And that's the purpose, is to grant a monopoly to someone to incentivize them to disclose information and to innovate. Copyright originated in censorship. Before the printing press, books were manually copied, and there was an elaborate system of censorship and control of the guys that manually copied these books, the scribes. The church had the list of prohibited books, and then the Stationers' Company in 1557 was established, and they were given the monopoly power to approve which books could be printed, mostly to suppress Protestantism and books about Protestantism. So copyright law in Europe arose from efforts of the church and governments to control what book could be printed. As Bolger and Levine, and Against Intellectual Monopoly, point out, Galileo's trial was in a way an exercise in copyright enforcement by the church. And then there's an example, for example, in 1637, the Stationers' Company seized and destroyed unauthorized books and presses. So it's clear book burning and censorship. So the roots of copyright are in censorship, and it's no wonder that today it leads to censorship, literally sometimes. There are cases I can cite you in the last 20 years where courts have ordered movie copies to be destroyed, or they've given an injunction against someone who was about to publish a book, saying you cannot publish this book. Literally control of thought and publication. One of the first full-fledged copyright statutes was the Statute of Anne in 1709. Only had 14-year terms, unlike around 100 or more today. And what's really interesting about this is the movement for some of these copyright statutes, like during the French Revolution, was by authors who they weren't trying to get a monopoly to sue people with. They were trying to get the right to publish their own works. So they were trying to seize it from the crown, or from all these monopolies that the governments would set up, which told the own authors, where their books could be published, or when they could publish their books, or which books could be published. So it was actually a fight against what we think of now as copyright. And I will close now. We can take a break, but let me read this one thing here. This is by Barbara, I think it's Barbara Ringer, who's actually not against copyright, but she has an interesting quote here, which I'll read here. My last quote I'll read. The pro-copyright theologians argue that copyright as a natural property right emerged from the mists of the common law. You see, this is sort of that immaculate idea of copyright, and took definite form as the result of the invention of the printing press and the increase in potential and actual piracy after 1450. They dismiss the historical ties between copyright and the Crown's granting of printing monopolies, its efforts to suppress heretical or seditious writing, and to exercise censorship control over all publications. This line of argument tends to infuriate the anti-copyright scholars, who point out that the first copyright statute in history, the Statute of Anne of 1710, was a direct outgrowth of an elaborate series of monopoly grants, Star Chamber decrees, licensing acts, and a system involving mandatory registration of titles with the State Insurance Company. Now, our question, this is the history of copyright and patent. The question is it justified now? But it's important to know what they are and to know where they came from.